pause here, this is not a minor charge. Aggravated kidnapping is one of the heaviest felonies on the books in Texas. 5 years to life. That's the kind of range where one decision in this courtroom can erase decades, or an entire future. And what's wild? He's about to take a deal that looks small compared to that number, but comes with consequences most people don't think about.
2023 CR 2763E, State of Texas versus Lazaro Alfonso Estrada Perez. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
Miguel Hernandez for the defense.
And is there a plea on one case only?
Yes, Judge, it should be on 2023 CR 2763E. There is something I wanted to bring up about discovery, though, but we can do that whenever that comes up.
All right. Are you Mr. Estrada Perez?
Yes.
All right. Okay, off the record for a moment. All right, everyone, do not approach the coordinator when I'm on the record. Everyone, this is the last case I'm calling before lunch. So everybody else, we've been here since 9. You'll need to be back at 1:30, the end. All right, we're back on the record. Are you Mr. Estrada Perez?
Yes.
Are you the interpreter?
Yes, Your Honor.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand if you'll state your name for the record.
Norma Nero.
Mr. Estrada Perez, all of the documents that I'm going to review with you, they are in English. For those documents, review with you in Spanish.
Yes.
And counsel, do you speak Spanish?
I do, Your Honor.
And do you speak it fluently?
I do, Your Honor.
And have you been able to communicate with your client in Spanish?
I have, Your Honor.
Counsel, have you received all the discovery? Did you review it with your client?
We believe we have, Your Honor, and I have looked it over as much as I can.
All right, and state.
Judge, so the reason why I wanted to bring this up is that there were 2 discovery acknowledgements filed in this case. One of them for this case number, and another one filed for the accompanying case number. My understanding is that on Verific and e-discovery, it shows up all the discovery on the other case, but it's the companion one to this one. So I'm just making sure the defense had access to that other one. I remember he dropped off the hard drive and I gave him a copy of everything.
We have, Your Honor, and we did look at everything.
All right, the court will find that the state is in compliance with discovery.
This discovery discussion may sound boring, but it's actually critical. Discovery is the backbone of a fair case. If the defense didn't get everything, this plea could collapse later. The judge locking this down on the record is her making sure there's no appeal angle hiding here. Question for you: do you think most defendants truly understand what's in that discovery, or do they just trust the process?
Mr. Estrada Perez, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we're proceeding on count 1, waiving count 2.
Any objection?
None at all.
Mr. Estrada Perez, did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense in count 1 of aggravated kidnapping? That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine.
Let this sink in. He's just acknowledged, on the record, that he fully understands he could spend the rest of his life in prison. This is the moment where defendants sometimes hesitate. But watch closely, he doesn't. That tells you the deal on the table must feel like the only lifeline left.
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent.
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Estrada Perez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
No.
Anyone promised you anything other than the plea?
No.
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
No.
Counsel, did you advise the defendant on his immigration status and the impact this plea would have upon him?
Yes, Your Honor, and he did have an interview for a Padilla letter, and they recommended, of course, that something a lot less than being offered, but because it is serious felony. And knowing all that, he's permission to follow the agreement.
Mr. Estrada Perez, did you have a chance to speak with an immigration attorney concerning the impact this plea would have on your immigration status?
And here it is, the silent killer in this case. Immigration consequences. Prison time ends, deportation doesn't. The judge is being painfully thorough because once this plea is entered, there's no "I didn't know" defense later. This single felony can permanently exile him from the country. Ask yourself, would you still take the deal knowing this?
Yes.
Do you remember that attorney's name?
No,
No, I don't remember.
This made Who was from the public defender? So yes, it was Miss May, Sarah.
All right. Did she advise you of the consequences of pleading no contest or guilty and the impact it will have on your immigration status?
Yes.
Did that advice include possible consequences such as deportation, the denial of naturalization, or re-entry into the United States?
Yes.
And do you understand the impact this plea will have on your immigration status?
Yes.
And knowing the impact this case will have on your immigration status, do you still wish to go forward with the plea?
Yes.
Court will find the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney and did you understand it?
Yes.
According to the plea, the state is proceeding on count one. They're asking that your punishment be assessed at 10 years in the prison. There are no applications. They're taking in consideration 2023 CR 2764E. Did you also understand that if the court find that there was a deadly weapon involved, the court will find a deadly weapon finding?
This part matters more than people realize. A deadly weapon finding isn't just a label, it slams doors shut. It limits parole eligibility, kills certain early release options, and follows him forever. Even with a plea deal, this detail makes the sentence significantly harsher in the long run.
Yes.
Did you understand that to be the entirety of your plea?
Yes.
State, is that the plea?
Yes, Your Honor.
Defense, is that the plea? Did you review the paragraph entitled waiver of appeal with your attorney? Did you understand it? Did you sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Then to count one, paragraph A and B, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offer states exhibit what all attachments.
We have just reviewed, Your Honor, no objections.
Thank you. Mr. Perez, did you have a chance to review the document entitled waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial? a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. After reviewing state's exhibits 1 and attachments, court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
We would ask that you follow the plea bargaining agreement made with the state, Your Honor, and impose a 10-year sentence.
All right, anything you wish to say, Mr. Estrada Perez?
No.
All right, the court will find you guilty. The court is going to sentence you to 10 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. Take in consideration 2023 CR 2764E. Is there anything else with regards to sentencing?
No, Your Honor.
Did you review the document entitled Trial Court Certification with your attorney? Did you understand it and did you sign it?
Yes.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes.
All right, and I'm also going to put in the judgment, no illegal re-entry into the United States. All right, if you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Mr. Estrada Perez, in this world, you have to learn one thing. And that one thing you need to learn is you cannot build your happiness on somebody else's misery. Do you understand?
Yes.
All right, good luck to you.
No, we excuse, Your Honor.
You're excused. All right, Norma, these are the people coming back at 1:30.
May I be excused, Your Honor?
Yes, thank you so much.
That final line from Judge Boyd isn't just advice, it's a verdict on the entire case. No yelling. No theatrics. Just a reminder that the law doesn't need anger to destroy a life, only procedure. 10 years in prison, deportation looming, no appeal, no weapons, no second chance. Was justice served here, or was this simply the least devastating option left?